Thank you, Mr. Siller. Good day, everybody. I'm so glad that people, a lot of my colleagues from Taiwan are here. They can cover my tails instantly. So I disclaim any liability if I say anything wrong without any correction. And I fully endorse what Dr. Feng has just said. You file in the U.S. first if you're thinking globally, because you can use the English version in Taiwan when you want to secure a filing date. And you can also, after more than 2 decades of harmonization, in practice and in the system in Taiwan, the most traditional forms, the claims forms like Jepson types and omnibus types, and the more particular newly developed forms like what they say, the parameter form claims, and you have these Swiss type claims, and certainly including the business model claims, are already well accepted in the Taiwanese system, and the examiners are churning out a lot of issuance, grants. So, I love USA, and sometimes I play the Star Spangled banners in order to raise my spirits when I feel a little low. But somehow, when you mentioned Mr. Siller was very kind, he saved me from sleepless nights. I told you about that the other day, just 3 days before, by proposing that you want to talk about the eligibility. And I was very glad, because I didn't pay attention to this issue until you raised it. And I didn't know that it would be, because does it cause any commotion, any stirring, any troubles in Taiwan? I don't think so. Because, we're happy that, to a certain degree, we follow a lot of policies that U.S., has been propagandized. But in this respect, we stay safe. We're still clear from that. And I want to tell you why. Because, when you want to determine, the Taiwanese system is a little different from the U.S. one, and the philosophy, I guess, is quite different. And in the Taiwanese system, just correct me if you find anything wrong, you have a definition of an invention patent, which says that it needs to be something using natural law, okay? And then that's the definition. And if you qualify the definition, then you go to the second criteria. That is the exception. If it involves therapeutic or diagnostic measures for human beings and animals, or if it is a plants or animal gene involving that. These are exceptions. If you clear all these criteria, then this is eligible. I think that's the philosophy. That's the system and logic in Taiwan. But I don't know what it was before the Alice case. But then after the Alice case, it seems to me that the U.S. guidelines gives you a non-clear-cut criteria to distinguish the eligibility issue. Like, for example, if you want to qualify a membership, you want to ask if you have more than $1 million in your account. You don't say that if you're attractive or you're beautiful or you're so popular in your neighborhoods. You don't leave this kind of discretion to the one who want to judge. And I think the new system is that, I'm not really supposed to delve into this issue, but what does it say? It says that the claims must recite additional elements that amount to significantly more than the judicial exception. And I think there are quite a few adjectives, and does it involve any adverbs? This is not what we, are applying to the eligibility issue. It is a lot easier. So, again, I want to go back to what Mr. Feng has just said. In general, the U.S. system is supposed to be more liberal. So you file in the U.S. That's a very good idea. And then you claim, and another sensitive issue is that I don't know how many people agree with me. Talking about the other day in the Japanese clients where, we went for an interview, and we talked about the case, a lot of cases are being filed in Taiwan and are being examined in Taiwan, while already the Japanese, the U.S., even the European, even the Chinese patents are already granted. So we use that to base the Taiwanese patents expedited examination. We can try to make it speed up the examination, and then very successfully we can obtain the patent in Taiwan. So in that order, we found out that it seems that the toughest area to obtain patent is Europe, EU. And then it will come down to the Asian zone, like, I don't know whether Japan is also one of the toughest one, and then it would just, slide to Taiwan, and then China, and then U.S. is the more lenient one. It seems to be the common sense. I don't know whether this is correct, appropriate to say so. So you may just file that, even when and another issue is the language issue. If you use the English version, you can automatically secure your filing date in Taiwan without any question, given that you submit your traditional Chinese version within 6 months after the filing date in Taiwan. And then you can just take your time. If you want to file a PCT, swift into the PCT within 12 months of your first, like you said, the provisional. Is it counting from the provisional one or not? I'm not sure. But it gives you 12 months for you to shift into the PCT, and then you have 30 months from the filing date of the U.S. date, right? For you to really just shift into the U.S., the Chinese market. So it would give you further time. Once you get the traditional Chinese version in Taiwan, you can modify that very easily into the simplified Chinese version in China. So that'll give you a very reasonable strategy, order for you to file globally. And another issue is that disclosure issue is not a big issue in Taiwan. We do not punish you out of any intentional or unintentional omission of disclosure in Taiwan, unless you lie in the procedure. For example, when you're filing a complaint to a certain party, seeking, for example, preliminary injunctions or even full-scale compensation out of an infringement case. And that happened before. But, an unintentional or intentional omission during the prosecution stage is not a punishable cause. So I guess, other things like, another thing is very, is kind of logistic, is that it costs you very modest for you to maintain or obtain a patent in Taiwan. The other day I talked to some of my colleagues in the office. It says that it costs you no more than $8,000 to, if it is a bigger case, it may cost you more than $15,000, but somehow the average falls on the $8,000 level for you to obtain a case, including the translation fee. And it costs you no more than, it's a very modest fee, $500 or $300 for you to maintain a patent, the annuity within 20 years. Well, the latter 10 years will just reach around $10,000, but $1,000. But earlier, former 10 years, it costs you no more than a meal in this hotel. So I guess that is all I have for now. Thank you.